documents while under custody at CMI without understanding what he was signing. So he denied ever participating in the murder. Courts of law rely on evidence before it. And if the evidence is a document, it should speak for itself to help court make an informed decision based on facts or inference. In this case, prosecution exhibit should prove, that is the charge and caution statement, should prove that the accused understood what a charge and caution statement means. That he understood the charge labeled against him, and that he was admitting that he, with others on the 8th September 2018 at Bulenga, unlawfully killed ASP Kirumira Muhammad with malice aforethought. He needs to understand that whatever he was going to say would be used against him in evidence. The document should also prove that he made the confession and signed it voluntarily and freely. Before relying on a confession, this particular case, the confession was recorded in English, yet Walimba told court that the accused told him he understands Luganda. On page 1, PW10 recorded the charge where he mentioned only Kirumira Muhammad and mentioned nothing about Rest Mbabazi, as if she was insignificant, yet 2 precious lives were lost. There is no evidence that he explained to him in a language he understands, yet he boasted of over 30 years' experience as a police detective. The same happened on each page where he recorded in English and just had the name of the accused written as signature. On the last page, that's page 26, he stated that that is what I can state, and the names of Kalunji Abubeka was written.
page number 26 tewali ekigambo ekigamba nti eyo yesobola okwogera era erinnya lya Kalungi Abubeka neriwandiikibwa.
AIP Walimba then wrote, charge and caution statement read back to the maker, being translated into Luganda by me, Detective AIP Walimba Stephen, and he has confirmed as true and correct. He appended his signature and rank of Detective AIP Walimba Stephen.
Mwami Walimba AIP n'awandiika statement eyo ezeemu n'esomebwa eri omuntu agikoze n'ateekako signature ye ne ddala lyaliko eri Detective Assistant Inspector of Police.
The accused, Kalungi Abubakar, did not countersign on this important part, that the document was read back to him and he confirmed it to be correct, yet throughout the pages he did not indicate that he read the contents back to him and he understood before signing.
Wali ekiraga statement ezeemu n'emusomebwa ng'akakasa nti byonna ebigirimu abitegedde bulungi empapula zonna nga teyalaga nti buli kiri ku peegi yakiddamu n'akimusomera agala kuteekako mukono.
This being a case involving the murder of his colleague and another, court expected the police officer to do better.
Musango gulimu ekyema eryokutta munnaawe yali esubira omusirikale okukola ebisingako.
Court believes a new police recruit could have done better because Walimba recorded the statement like he was recording for himself, not to be used as evidence in court.
Ekiriza nti singa aliwo omuntu omusirikale omulala yali aleeteddwa yandibadde akola bulungi okusingako Walimba. Walimba yawandiika nga yali yeewandiikira nga tasobola nti kiyinza okukozesebwanga obujulizi mu kkooti.
He did not only fail to record it in the language the accused understands, but failed to interpret to him, to his understanding, because he never signed to confirm that the document was read back to him in the language he understands and wrote his names against that affirmation.
Yalemera okulemerwa okuwandiika mu lulimi avunaanibwa abategeera naye yalemera n'okumunnyonnyola.
Holding. The trial court has to examine the circumstances of the case and all other corroborative evidence to determine whether the confession can be relied on as evidence or not.
Nga basinziirako ebyo n'ebiyiza bisalibwawo, kkooti erina okwetegereza embeera eyaliwo mu musango guno n'obujulizi obulala bwonna obuyinza okukwatagana okulaba oba ebyayokerwa statement eyo bisobola okwesigamizibwako ng'obujulizi oba nedda.
Admitting a document in evidence does not automatically make its contents truthful.
Okukkiriza ekiwandiiko ekyo ng'obujulizi tekitegeeza nti byonna ebigirimu bya mazima.
Cross-examination can render such a document irrelevant. In the instant case, the last paragraph on the last page of the confession, where the recording officer stated that charge and caution statement read back to the maker, being translated into Luganda by me, Detective AIP Walimba Stephen, and he confirmed as true and correct, was only signed by Walimba, not the maker.
Detective Assistant Inspector of Police Walimba Stephen era ng'akakasa nti bituufu n'eteekako omukono nze Walimba naye eyagikola teyateekako omukono.
This distinguishes this charge and caution statement from those that are signed by the accused, confirming that they have understood.
Ekikola statement eno ey'enjawulo kwezo ezizo ezikolebwa abavunaanibwa abaala nga bakakasa nti ebigirimu bituufu ne bateekako emikono.
The presumption that the accused suspect understood before he signed can only be made if the document is properly endorsed by the suspect, including the crucial part of where it is stated that the contents were read back to him to his understanding. Caution statement dated 29 September 2018 clearly shows that the accused did not sign and confirm that the contents were read back to him in Uganda, understood and found the contents to be correct.
Era kabulungi nti avunaanibwa oba yakola statement eyo teyateekako mukono era teyakakasa ebyo ebyali mu statement eyo nti bizzeemu ne bimusomerwa mu lulimi Oluganda nti oba yabitegeera.
Court further observed that the contents of the charge and caution statement from page 2 to 4 had nothing to do with the charge against him.
Kkooti yagenda maaso n'okwetegereza nti ebyali ku peegi namba 2 okutuuka ku peegi namba 4 ya statement eyo ebyalimu byonna byali tebikwatagana ku musango ogumuvunaanibwa.
From pages 5 to 7, the maker is talking about being told by a one Katerega to go to Bulenga to locate the motor vehicle of Kirumira from the parking, and that he went and did not find it there.
Okuva ku peegi namba 5 okutuuka ku peegi namba 7 eyakola statement eyo ayogera ng'eki yabuulira Katerega kugenda mu bitundu by'e Bulenga okulaba mmotoka ya Kirumira ng'eva mu paakingi bwe gye yatuuka era nga teyasobola kugisangayo.
He then wrote, and I quote, "I went back on 8th September 2018 at about 19 hours, and he found the vehicle parked outside on the road near the parking, and immediately called Katerega on phone, and he came riding a motorcycle TV Kiwaji, carrying Hamza Mwebe. Mwebe Hamza was armed with a rifle, went to where the vehicle of Kirumira was. I had gone close to them, and I had identified Kirumira with a lady in the said car. I went where Katerega had parked his vehicle up at Northern Bypass. Before I left, Mwebe Hamza had already moved to where the vehicle of Kirumira was. I had gunshots as I moved away." He does not state anywhere that he knew the reason why Katerega wanted him to locate the vehicle belonging to Kirumira, or that he knew that they were planning to kill him, and he was to assist them in the murder by locating his motor vehicle, which would make him an accomplice in crime.
Talina bw'ayogerera nti yali amanyi lwaki Katerega yali ayagala okutegeera emmotoka ya Kirumira, oba nti yali amanyi nti baali beetegekera kudda omwami oyo, nti yalina kubayambako mu ttemu eyo nga afuna mmotoka y'omwami oyo ng'ali asimbye nga kimufuula okubeera omu ku bayambako abantu abo okuza omusango.
PW6, an eyewitness's narration of what transpired on that fateful day and hour, is very different.
Omujulizi ow'omukaaga eyaliwo ng'ebibaawo mu kwogera kwe ng'anyonnyola ebyali ku lunaku olwo n'essaawa eyo byawukana nnyo.
He described the motorcycles as sports motorcycles, and that there were two, not one, as stated in the charge and caution statement, which was retracted. Page 24. Whereas in the charge and caution statement, the author stated that the accused moved nearby and saw the deceased Kirumira with a lady, the witness who engaged Kirumira for about 3 minutes informed the court under cross-examination that there was no one nearby, and no sooner had the lady entered the vehicle than the two motorcycles of the assassins came and started shooting.
yatambula n'agenda okumpi w'omugenzi Kirumira oluvannyuma ng'alina omukyala. Omujulizi oyo yagamba nti bwe yayogera ne Kirumira ku madakika nga 3 yategeeza kkooti nga balibako bamubuuza tewali muntu yenna yali kumpi awo, naye oluvannyuma waliwo omukyala eyajja n'ayingira mu motoka, era oluvannyuma lw'ekyo pikipiki 2 ezaaliko abatemu abo zajja ng'ezitandika okuba amasasi.
Whereas there is only one motorcycle with 2 people, the eyewitness mentions 2 motorcycles with 2 riders on each, and they all actively participated in the murder. The first one shooting in the air to scare off anyone and the cars from approaching the murder scene, while the other was shooting directly at the deceased.
ng'eriko abantu babiri eyaliwo ng'etemu eno libaawo yayogera pikipiki 2 nga ziriko abantu babiri buli pikipiki, era nga bonna benyigira mu ntemu eyo, nga abasooka bali bakuba amasasi mu bbanga okugobawo omuntu yenna ayinza okubeerawo, nga wasembera emmotoka eyo, ng'ate abalala baali bakuba nga batebera ddala mu mugenzi.
The evidence of the eyewitness does not corroborate the charge and caution statement at all. A charge and caution statement, which is treated as a confession, must be unequivocal. It must be unequivocal. It must show that he committed the offense. It should not be open to more than one interpretation or leave any doubt as to the guilt of the accused. AIP Walimbwa also stated that he knows Luganda because he studied it in primary 1 and 2. And has worked around Uganda-speaking region for a while. Incomprehensible for anyone to claim to be an expert in a language after learning it in primary 2. The Uganda police force has very many people from Uganda. For Walimbwa to claim he learned his Luganda in P2 was an admission that he does not have a good written command in the Luganda language. He can speak but cannot write it. For anyone to qualify to be an interpreter in a language, one must be fluent in speaking the language as well as writing it. In his defense, he denied ever knowing or having any relationship with Katerega and that he met Hamza at court as the co-accused. He informed court that he went through serious torture from the moment he was arrested and forced to write his name or append his thumbprint on documents to save his life. Indeed, Police Form 24A, that was admitted and marked as PE18, confirmed that he had healing bruises on the forehead measuring 2 centimeters by 2, lower lip measuring a half times 1 centimeter, small multiple wounds on the back, tenderness on the left wrist, which injuries were less than 1 week. The prosecution did not adduce any evidence to prove that he was arrested with those injuries or that he did not get them while under the custody of the police or CMI. On the issue of Katerega asking the accused to do surveillance on the late Kirumira, the prosecution did not adduce any evidence showing the true identity of Katerega or whether truly he lived and died. All that court heard was hearsay evidence that he was put out of action. No security officer came to court to confirm that he put Katerega out of action and or explained the circumstances under which he was put out of action. Counsel for the accused submitted that no post-mortem report was tendered in court, proving that one Katerega was identified by a relative or anyone who knew him and indeed died. Apart from telling court that he was put out of action, no witness explained to court how he was put out of action and how his body was disposed of. Was he handed over to the family for burial? Nobody informed court that they attended his burial. His existence and death remains mysterious. The Land Assistant DPP submitted that in the Androa case, court relied on the confession made by the accused. Androa case. The facts in that case are distinguishable from the facts in this case, in that the confession in that case was collaborated with some other evidence like the note that was recovered from the accused, where he mentioned the name of Professor Mudola he had murdered. He was also arrested after he went for help from a witch doctor to silence the ghost of the deceased persons he had murdered by hurling a grenade. Therefore declining to rely on the police charge and caution statement based on 3 main reasons.
kkooti ejja kuganda okwesigama ku statement eyo ng'esinza ku nsonga zino ssatu.
1. The charge and caution statement was recorded in the English language, not Luganda, the language understood by the accused, and he never endorsed on the crucial part where he ought to have acknowledged that the contents were read back to him in the Luganda language, and he understood before signing or writing his name.
Statement eyo yawakola omulimu oluzungu obutali Luganda akumanyi nga bwategeera obulungi era teyateekako omukono mu kitundu awali ekitundu ekiraga nti omuntu yategeera bulungi ebyali mu statement eyo era statement eyo ezeemu n'emusomebwa olulimi Oluganda lwategeera obulungi nga tala kuteekako omukono oba okuwandikako erinnya lye.
2. He was found with healing torture marks on 2nd October 2018 when he was examined, which was about 4 days before he recorded the statement, with one healing wound on the forehead and multiple on the back, which fact PW10 Walimbwa claimed he did not see, which is unbelievable since the one on the forehead was apparent to the naked eye.
Ensonga ey'okuyita yasangibwa ng'alina ebisago ebyali bigenda bibona byeyafuna nga 2/2018 mu kiseera kye bamukebereramu ng'ali wakayita nnaku nnya nga yakakola statement eyo ng'ekimu ku kyo
4 days before.
Nnaku nnya nga tannabakola statement eyo ng'ekimu ku kyo yalina ekisago mu bwenyi nga kino kyandiba n'ebirala ku mugongo nga omujulizi namba 10 Walimbwa yagamba nti mutabiraba ng'ate ekyali mu bwenyi yali asobola okukiraba n'amaaso ge.
3. The author of the charge and caution statement, Walimbwa Stephen, was found not only to be incompetent as an interpreter in Luganda language, but lied about the condition of the accused. Court has no cogent reason to doubt the defense that he was tortured and coerced into writing his name on the confession to save his life.
Ensonga ey'okusatu n'eyawandika statement eno tuyiga omujulizi ow'ekkumi mwami Walimbwa Stephen yasangibwa nti si omuntu tasobola kuwuundula bulungi mu Luganda era yalimba ku mbeera y'omwami eyavunaanibwa. Kkooti erina nsonga yonna okuziganya ludda olw'obunaanibwa nti omwami oyo yatulugunyizibwa era n'akakibwa okuteeka erinnya lye ku statement ey'okutaasa obulamu bwe.
Section 24 of the Evidence Act, Chapter 6, Laws of Uganda, is very clear on when the confession is irrelevant.
Section namba 24 mu mateeka gabagobera nga w'obujulizi mateeka ga Uganda ennyonnyola bulungi statement eyo etasobola kubeera ya mugaso.
A confession made by an accused person is irrelevant if the making of the confession appears to the court having regard to the state of mind of the accused person and to all the circumstances to have been caused by any violence, force, threat, inducement, or promise calculated in the opinion of the court to cause an untrue confession to be made.
Ng'egamba nti wabaawo statement eyo n'ekoleddwa avunaanibwa ezotwalibwa nsi ya mugaso singa wabeerawo.
Unsafe to rely on the charge and caution statement recorded by Walimbwa Stephen, as it is tried law that a confession obtained through torture has no evidential value as it is irrelevant.
Ensonga ezisatu ez'okugeddwako waggulu kireetedde kkooti n'okutesitema ku statement eyo yakolebwa mwami Walimbwa Stephen omujulizi ow'ekkumi kubanga kiri mu mateeka nti statement ekoleddwa oluvannyuma lw'okutulugunya omuntu terina kyamaanyi kyereeta kubanga eba si ya mugaso.
Well, in all my findings that the prosecution exhibit, that's the charge and caution statement, was far from the definition of a true confession as the whole process of obtaining it and recording was flawed. This takes me to the second piece of evidence, a call detail record. The second piece of evidence the prosecution relied on to prove participation was the call detailed record. A call detail record is a data record produced by a telephone exchange or other telecommunications equipment that documents the details of a telephone call or other communications transactions that passes through that facility or device. 537986 was given. The prosecution further tendered in prosecution exhibit PE13 an order to the head cybercrime unit, Directorate of Forensics, to inspect and extract information from the computer, mobile phone in accordance with the procedures and requirements of digital and electronic evidence, section 28(1), 2, and 3 of the Computer Misuse Act of 2011.
Ekigenda w'omukulu atwala ebyokunoonyereza ku misango egyo ku byuma bya kalimagezi nga alina okwetegereza era afune amawulire gonna gakwata ku simu ezo oba ebyuma bya kalimagezi nga bakoberera amateeka ago agakola ebyuma bya kalimagezi section namba 8 n'esooka ey'okuna ey'okusatu.
Forensic science or application of science methods and techniques to investigate crime, when properly done, is one of the best evidence of establishing facts. It involves gathering and analysis of all physical evidence related to a crime in order to reach a conclusion about a suspect. The mobile handset used in communication is a very important exhibit in criminal investigations. And where one changes a SIM card to another handset, it can clearly be established. Not a single handset was tendered in court, but just phone printouts, which when looked at as is, cannot show the subscriber. I have, however, studied exhibits PE15 and PE16 and established that the users of the two mobile numbers 0702843480 and 0752537986 communicated before the murder, after the murder, and around the time of the murder. as well as other numbers, especially on the fateful day of 8th September 2018. But for reasons best known to the prosecution, the investigating officers did not investigate those other numbers. Telephone number 0702-843480, code number 0712-46277, while picking Kirumira must at 18:13:06 seconds, and the communication lasted for 122 seconds. The number again called number 0701246277 at 18:32:64 seconds. And they communicated for 65 seconds. The number also called number 0745400904 at 18:40:11 seconds. And conversed for 26 seconds. It called mobile number 0752537986 at 18:49:16 seconds and conversed for 92 seconds. It called number 0701260927 at 18:51:15 seconds and talked for 65 seconds. Happened around that time. Why was the investigations not wide enough? Why was it so narrow and yet the two numbers of interest communicated with other people? Who was the registered owner of mobile number 0745400904? Who communicated with the holder of number 0702843480 5 minutes? What about the holder of number 0712600927 who communicated with the same number at 19:53:09 for about 1 minute shortly before the alleged murder time? Nakawude and Kirumira are distinct masks. They show different locations of the caller or receiver and shows people are not together. On 8th September 2018, the two numbers picked Lubya and Nakawade masts, which are stated to be near Bulenga. The murder scene. Yet Bulenga is stated to have its own mass according to PW11 Nyakairu Frank. In his report, Procession Exhibit 10. Further scrutiny of the two numbers revealed that the subscriber of mobile number 0752537986 communicated to number 0702843480 on 8th September 2018 at 20 hours 01:09 seconds. But the site name or mast location was not indicated on the call data as per Procession Exhibit 15 of the user of the mobile line. Looking at Prosecution Exhibit PE11, allegedly prepared by Nyakairu Frank, the caption of his document was titled Joint Technical Communication Chart for ADF Operatives. Now that is in English. Say it in Uganda. He went ahead and indicated those that have been arrested. The document did not have anything to do with the murder case of ASP Kirumira and Resti. Much as the document indicated that most of them were arrested, none of them was called to confirm to this court that the murder of Kirumira and Resti was done by ADF operatives. Besides, Prosecution Exhibit 11 showed that Kalunji communicated once with a one Katerega Abud, contrary to Prosecution Exhibit PE15 and PE16. The call data for the numbers indicated thereon as 0702843480 and 0752537986. He did not indicate how he got the particulars of the names and photographs of the people he put on his document. His document PE11 therefore raises a lot of doubt as the source of his information is questionable, leaving his document with no evidential value in as far as this murder case is concerned, as this court was not investigating communication between ADF operatives.
leetawo okubuusabuusa kungi wajja kufuna amawulire ago kubanga ekiwandiiko tekirina bujulizi bwe kireeta ekikwatagano.
The undated technical report on suspected murderers of the late Kirumira Muhammad, which was admitted and marked as PE10, does not indicate how Frank Nyakairu, the senior investigating officer, got to know the subscribers of mobile phone numbers 0752537986, stroke 0756583180, stroke 25670284348, stroke 0782990487, and stroke 0701193818 as Katerega Abudu, Kalunji Abubeka, and Hamza Mwebe.
Ripoti eyakolebwa etaliko nnaku z'omwezi erimu abateeberezebwa okutta Kirumira Muhammad zakkirizibwa kkooti ekitiibwa ekizibu namba 10 ekiraga ngeri ki mwami Frank Nyakairu
showed Bulenga at the critical time of the murder or shortly before. This makes his report to be treated with a pinch of salt.
Era nga ku peegi namba 2 nti Katerega Abudu esimu yali efuna omulongooti gwa Bulenga naye mu mpapula ezaaliko eziraga empuliziganya zaali tezifuna mulongooti gwa Bulenga mu kadde kennyini obanga etemu erinaba kubaawo.
I know the law does not allow the telecom companies to just print out text messages for privacy reasons, but they can be obtained through a court order, which was done, but without purpose in this case.
Kimanya amateeka tegakkiriza bitongole by'amasimu okufulumya mpapula ezo eziraga empuliziganya byebaddewo olw'ensonga ez'omuntu zekinoomu naye nga zisobola okufunibwa nga waliwo ekiragiro kya kkooti,
Which was done in this case,
nga kyakolebwa mu musango guno
but it was without purpose.
naye nga tewali kigendererwa.
No text messages were printed out to ascertain what was communicated, yet text messages were sent.
Tewali message yonna yafulumizibwa ate nga kiraga nti waliwo message zebaali beeweereza.
You can tell from a text message the motive of the conversation.
Osobola okutegeera oluvannyuma lwa bubaka obwo ekigendererwa ky'emboozi eyo.
Nothing of significance was from Nyakairu Frank, who seemed to be an expert working with CMI, and the prosecution relied on him as their star witness.
Tewali kintu kya mugaso kyafunibwa okuva ku mwami oyo Nyakairu Frank eyalabika nti mukugu nnyo ng'akola ekitongole kya CMI ng'ate oludda oluwali lwamwekitamako nga omujulizi wa kabiri.
Yes, he might be good at tracking phones, but did not help the prosecution in adducing evidence of participation.
Ayinza okuba mulungi okulondoola amasimu naye teyambako olulungi lwali kuleeta ku nsonga eyo bakalekirira.
His investigations were basically to track the accused for purposes of having him arrested as an ADF operative who was suspected to have been involved in the murders of Kawesi and now this case.
Okunoonyereza kwali kulondoola abantu
Defense as a carpenter who roofs houses, and that he had not gone to work but was running away from being arrested.
olugwe lwaki lwasobola kulemesa kusoloozaako kwemwami oyo yali mubazi ng'ateeka ennyumba era mu kiritu yali agenda okukola ng'ayekatisa emisango.
This part of information in a case that has no direct evidence is very important.
Amawulire gagalaga omusango gunako oguliko obujulizi obutasonga mu nsonga eyo bwa mugaso nnyo.
Who was his host in Bulisa?
Ani yali amukyaziza mu kamuzi y'ebulisi?
What had he gone to do?
Yali agenze kola ki?
According to the printout, the number PW11 was tracking clearly shows that the person was extremely mobile, and picking Nakawade Lubia mask was not only on the particular day, but even in July and after the murder. Picked those masks. Evidence did not therefore prove that the holders of the questioned mobile numbers were strangers in that area. They were there long before the murder, as early as July 2018. PW14 Kabera Francis from Airtel, who tendered in the call data for telephone numbers 0752 537 which was requested for by Masete George as per prosecution exhibit PE9A, the affidavit, and was given a court order marked as PE9, exhibited the call data. What did it disclose? The defense tendered in exhibit DE4, which was a letter to the Director Forensics, Police Headquarters, to investigate the numbers for the late Kirumira and the numbers for Resti, and the numbers for Mrs. Kirumira, and one Ali Kabanda Bashir. And one Kalema Lawrence. This was a step in the right direction. However, nothing was adduced in court showing the call data detail of the late Kirumira and Rest, just like those other numbers that picked Lubia Nakuwade masts at the critical hours towards the black hour of the gruesome double murder. One watching a horror movie where one is very sure it is just but a movie. It is just but a movie. His courage and confidence to remain standing and watching the shooting at the vehicle, several bullets at the driver's seat, co-driver's seat, while several bullets were shot in the air to scare off every other person from approaching the murder scene from all sides, which was confirmed by the bullet-riddled bodies of Kirumira and Rest, cannot be explained as it is a contradiction of the natural instinct of human beings when faced with imminent danger. He said it was like from the witness dock and column outside the courtroom, which was indeed too close for anyone to remain standing. The murder of Kirumira and Resti was ferocious and savagely brutal. The assassins used the bullets according to evidence. A single gun-wielding man can scare a civilian person and even a trained but unarmed person. Can scare, not kugoba, scare, kutisa. Even a trained person. Watching anyway and keeping watch over the place until the arrival of His Excellency the President. Prostitution Exhibit PE4 and PE5, the sketch plans of the scene of murder, though not drawn on scale, do not show where this indomitable lion of a man was standing. In his evidence, he said he did not see any other person nearby. Yet the sketch shows that the crime scene was having many shops around, which ideally attracts people around. In my humble observation and opinion, PW6 Chigongo Abudu should have been investigated over this rare courage and confidence that the assassins who acted in the most gruesome and brutal manner could not harm him as he watched them kill two people whom they must have seen him talk to because he had hardly moved away from the car than they struck as per his own evidence. Were not systematic and properly done to discover and examine the facts. The suspicion that the assassins were ADF rebels, according to PW11 in Nyakairu, was the beginning of mismanagement of the criminal investigations of this gruesome double murder with impunity. The prosecution requested court to take the evidence of PW11 in camera, but this being a criminal matter, court could not close doors but ordered all the pressmen and other people out. Much as defense exhibit DE5 mentioned a one Jamil Mwonge, but the information remained as hearsay evidence, which is not admissible since Jamil Mwonge was not called as a witness. A smart investigator in a high-profile case like the instant one, where there is no direct evidence, would have thought of the option of getting the text messages to ascertain what the text messages between suspects were about. Courts overall rely on facts and not imagination or suspicion, for suspicion, however strong it may be, can never be a basis for conviction. The investigating officer in this case did very shoddy work It's not enough to get call data and imagine it's enough to prove participation. Moreover, without getting concrete evidence of the identity of the persons who are communicating. In the instant case, the prosecution relied so much on the call data between two mobile phone numbers, alleging that one was for the accused and one was for Katerega Abudu. The prosecution, who is Katerega Abudu? The prosecution did not adduce any evidence of identification of Katerega Abudu, much as they allegedly got his number in their radar as an ADF operative. The prosecution informed the court that Katerega is the person who instructed A1 to do surveillance on the late Kirumira and was put out of action. No evidence of his killing or death was ever adduced before court to confirm that Katerega existed and was the person who instructed A1 to trail Kirumira. It is straight law that death may be proved by production of a post-mortem report or evidence of a witness who state that they knew they are deceased and attended the burial or saw the dead body. If at all he was put out of action, that amounted to extrajudicial killing, which is not allowed in law. Katerega remains mysterious as well as his involvement in the murder. These questions remained unanswered, yet if the prosecution provided answers through evidence, there would be no doubt as to who killed the deceased. Who is Katerega? Why would he kill Kirumira and Resti? Where did he get the guns that were used during the murder? Why was he put out of action when it was necessary to establish the motive for the gruesome murder? Did they find any weapon with him? If that is the reason why he was put out of action, where is the weapon that was recovered to trace the supplier of the weapon? The supplier who supplied the weapon. It is general knowledge that guns and bullets are a preserve of the Uganda Police Force. Uganda People's Defense Forces and Uganda Prison Service. Where Ugandan citizens are gruesomely murdered, like in this case, using weapons that are a preserve of our security forces, it is important that investigations are taken seriously to the extent of establishing the kind of weapon that was used.
nga lino nga bakozesa ebyokulwanyisa ng'ebyo ebisuubirwa okubeera n'ebitabo ebyokwerinda kiba kya mugaso nnyo kiyamba mu bibukuno by'okunoonyereza.
It is not known whether the investigators in this case ever thought of tracing the source of the murder weapon.
Tekimanyiddwa oba baba kunoonyeza ku musango guno bagezaako okutegeera ekiisi ekyo kye kyali kiva.
If at all they were convinced Katerega had a hand in the murder, they should have not killed him, but arrested him to obtain his statement and retrieving the murder weapon. If at all he was killed, the police that was investigating the gruesome murder of their very own and another should have exhibited what was in his possession that made him dangerous to the extent that he had to be put out of action in defense of their own lives. Or what he had, which had any connection with the murder. What was it that those who put him out of action were fearing or concealing? We have a well-established criminal justice system that does not necessitate extrajudicial killings of suspects. This court condemns this kind of conduct as it violates the constitutional right to a fair hearing